Madam. Sir, go ahead.
Good evening to all of you. Today we deal with the topic of mortgages contained in section 58 to 104 of the Transfer of Property Act. First and foremost is, before we go to mortgage, we must have a thorough knowledge of the Contracts Act and more particularly the Specific Contracts Act. And this mortgage is almost akin to a topic in the specific contracts called pledge or pawn. Here again, before going to these mortgages, I'll define what a pledge or what a pawn is as far as 174 to 178 of the Contracts Act is concerned. Where movable property is offered as security, please underline the word movable property. Where movable property is offered as security for the due repayment of a loan paid, promised, and the person who offers the movable property as security is called the pawnee or is called the pledger. And the person to whom the movable property is offered as security is called the pawnee or is called the pledgee. And the transaction is called a pawn or pawn, P-A-W-N, or pledge, P-L-E-D-H-G-E. So mostly this law of pawn deals with gold ornaments. That is where gold loan you obtain a loan for loan pledging your jewels, and then you get your loan. That is what is called a pledge. And for redeeming the pledge, the 3 years period is mentioned, and you have to pay the EMIs EMIs also as contemplated or as contracted for. And after the entire amount is paid, you are entitled to get back the jewels duly redeemed. And the right that is available to the pawnee or the right that is available to the pledger is to get back the jewels duly redeemed. And the right which he exercises is called the right of redemption. Right of redemption or restoration, or whatever movable property is offered as security, you are entitled to get it back. And please remember the time within which you must exercise that right is 3 years. Within 3 years or within 2 years, as you have contracted for, you have to pay the money to the bank or the financial institution from where you are placing your jewels. And once you do not pay, the pledgee or the pawnee has got a right of exercising his right of lien or right of detention as it is called, and he can sell that movable property and then recover his money. But it's subject to giving 15 days or 1 month's notice to the pawnee to make good the money what he has promised or what he has taken as loan as are based on the jewels which are offered as security. This is what is called a law of pledge or law of pawn, as laid down in the Indian Contract Act and more specifically the specific contracts. The same way, as far as transfer of properties and in Telugu, especially pledge or pawn, you can call it as kudu, or you call it as rehen. Rehen is the Rehen means pledge, or kudu. Kudu means it is called a pawn or it's called a pledge. But when we come to immovable property is not covered by the Contracts Act, but it's covered by the Transfer of Property Act of 1882, which says that immovable property. Please remember, Section 58 defines a mortgage as, where, please underline every word, where interest in respect of specific immovable property is delivered or transferred by a person called the mortgagor to a person called the mortgagee for securing a debt paid, promised, part paid, or part promised. Why I'm saying why it is defined as interest in specific immovable property, sir? Interest can be proprietary, interest can be possessory also. So the question is interest in respect of interest specific, that is interest in respect of specific immovable property. Please underline that word. It is not movable property. Specific immovable property
where an interest in respect of specific immobile property is created by the mortgagor in favor of the mortgagee to secure a debt paid, promised, part paid, or part promised. So here, why the word interest is used, sir? Interest means proprietary interest, titular interest. It can also be possessory interest also. That comes within the ambit of mortgage. Mortgage in Telugu, normally in the agency area at Srikakulam, Vizag and all, they call it as Tanaka. But here in Telangana, we call it as what is called Rehan, or we call it as Girvi. I'm sorry, Girvi. Because please remember, in Telangana it is half Telugu and half Urdu. That's the reason why the word or Takatu, as you may call it, or an encumbrance that is created. But Takatu means only encumbrance. But here that is it is said that is Girvi. Girvi means where immovable property is offered as security for the due repayment of a loan, paid promise, part paid or part promise. The person creating that interest is called the mortgagor, and the person to whom the interest is created is called the mortgagee. And a relationship of debtor and creditor is created by this transaction. And for what purpose? To secure a debt. Debt means money transaction. Paid, promise, part paid, or part promise. I'll tell you why. Why do you say part promised or part? Here, when you go to a financial institution, more particularly a bank, you require money as loan for your working capital arrangement or for other arrangements like bill discounting, cash credit, money type, and so on and so forth. Or that is a hypothecation through pledge of mobile property, so on and so forth. Please remember, no creditor will advance money to you unless you offer some property as security. And the reason is the creditor wants to safeguard his interest. The monies which are lent by him, he wants to get it back in toto. That is the reason why he insists on what is called collateral security or mortgage. And that interest which is created in respect of immobile property for the purpose of payment of a loan, paid promise, part paid or part promise, it is called a mortgage. I'll come one by one. Why do you say part paid and part promise? Here, as far as the banker is concerned, suppose you apply for a loan of 50 lakhs, let us say, the banker will not release that 50 lakhs immediately. What he does is he releases it by stages by stage. Suppose, let us say, you apply for a house loan, home loan rather. You want to construct a property with the loan obtained from the bank or what is called home loan or housing loan. Then till the foundation or till the pillars are laid, a particular amount is released. Then next after that, roof level, some amount is released. After the roof level, the finishing amount is received. Then once it is fit in all respects, the entire amount is released. It is released in part by part by part by part. And suppose a loan is advanced based on the raw materials that is available, and it is offered as pledge or it is offered as hypothecation. Please remember here, before we go into it, you must know there are two types of charges under the law. One is called a floating charge and another is called a fixed charge. Floating charge means you know how a leaf tries to tries to move in water. That is, it doesn't remain in one place. It goes on and on and on and on. So the question is, once the loan is released, it is a leaf floats in water. That is, primary documents are taken at the time of sanction of the loan after appraisal, and then a promissory note is taken, a risk DP note as they call it. Then they take agreement. Then after that they take various documents, and they also take what is called collateral security. Also, if immobile property is offered as security for securing the loan, then the documents which are already executed stands good for future advances also. The fresh documentation is not done. It is done at one stage when the sanction is done. Here, it is released in phases, it is released in stages, and every time the loan is, for example, suppose the loan is released for a textile company. Then let us say raw materials arrive. Once the raw materials arrive, you convert it into the purchase of raw materials is done out of the bank loan. Then after that, the raw material is converted into finished product. And once it is converted into a finished product, it is sold in the market. And whatever money you realize from out of the sale of the finished product, you have to route it through the bank, and the bank you have to deposit in the bank. Then again you apply for, then the other stages. You again get raw material, convert it to the finished product, sell it in the market. Like this, things go on. Every time when the stock comes in, either be it a raw material or be it a finished product, a charge is created over the raw material, or what is called the raw material which is pledged, or the finished products which are pledged with the bank, and the bank has got the first charge over that. And periodically they inspect the stock register, they inspect the sale register, and see that it's properly done, and all the transactions are routed through the bank. And please remember one thing: it is called a floating charge. Floating charge means it tries to swim like, it tries to move in water like a leaf in water. And then suppose, let us say, the loan becomes bad, and the loan is transferred to the recall debt, and it becomes an NPA, or what is called non-performing assets. Then in that case, the bank recalls the debt and then transfers it into an account called protested bill account, and issues notice to the debtor or to the mortgagor to make good the payment, whatever is due and payable as far as the loan is concerned. And first, the bank has got the charge over whatever stocks are available in the godown, whatever finished product is available in the godown, and whatever transactions take place, they have to be routed to the bank, and they shall not be irregular. It should not be a irregular operation. And once the bank recalls the debt, it becomes a fixed charge. Otherwise, it is a floating charge. It goes on floating in water till such time, so long as the amount is paid, no bothers. But once the amount is not paid, it becomes a fixed charge. Then one more thing you must remember is, as far as mortgage is concerned, the question is if a mortgage can arise only regarding money transactions. Please underline that word, money transactions. It cannot arise regarding any other transaction. Next, third one is, there should be a relationship of creditor and debtor, or surety also. And various documents are taken in support of the loan, which is advanced by the bank or a financial institution. And what is offered as security, sir? Specific interest in specific immobile property. Please underline the word specific immobile property. That means there cannot be a mortgage as far as mobile property is concerned. As far as mobile property is concerned, it is covered by the law of pawn or law of pledge as embodied in the Contracts Act from section 172 to 177. The immovable property transactions are not covered by law of contracts, though it's a species of the law of contracts, but law of contracts is different. Transfer of Property Act is different. Why do we call it, again I repeat, sir, why do we call it as interest in specific immobile property? That means it can be a proprietary interest, it can be a titular interest, it can be a possessory interest also that can be created. But one good thing you remember is that a mortgage transaction can take place only regarding money matters. Regarding other matters, there cannot be a mortgage. And there must be a relationship of creditor and debtor. Number two, there must be a security offered. And that security is an interest created in respect of specific immobile property. For what purpose, sir? For the purpose of securing the loan that is advanced, paid, promised, part paid, or part promised. So this how the section has to be elaborated. Though the section is only 3 lines, but every word has got its own importance. And first and foremost, you must remember is a mortgage transaction can take place only regarding immovable property. Number one. Number two, there must be a relationship of creditor and debtor. Number three, there must be a monetary liability owed by the debtor to the creditor. Fourth one is to secure that monetary liability, collateral security is given, that is, an interest is created in immovable property, a possessory interest or a titular interest. And other consideration is, what is the consideration which the banker or the financial institution gives? They advance the loan, pay, promise, part paid or part promise. Such a transaction is called a mortgage under section 58. And the person who offers the property as security is called the mortgagor, and the person to whom the property is offered as security is called the mortgagee. And the consideration for either of them is amount is advanced, and for the amount being secured, immovable property security is taken either in the form of a titular interest or in the form of a possessive interest. This is how the section 58 has to be elaborated. Then we have to define what do you mean by hypothecation. Hypothecation is not defined in any dictionary, please. Hypothecation in loose terms, it is called pledge of immobile property. Then you can say, sir, how can a pledge arise in immobile property? I explain to you, sir. See, suppose you want to set up a printing press. You go and acquire a machinery with a bank loan. Then machinery cannot be kept just outside. You will have to fasten it with nuts and bolts. But once the machinery is loose, without being fitted with nuts and bolts, it remains a mobile property. But once it is attached or embedded to the earth or fixed to the earth permanently, it acquires the characteristics of an immobile property. And what is the printing machinery, sir? Printing machinery is mobile property. And there can be a bridge of mobile property. But it is called bridge of immobile property because the bridge or the hypothecation attaches to the entire machinery which is fixed to the ground, attached to the ground, fastened with nuts and bolts. It is called hypothecation. And the machinery which is offered as security is called the hypotheca. Hypotheca, Hypotheca. And the person to whom it is offered as security is called the hypothecatee. Of course, the person who offers it as security is called the hypothecator, and the transaction is called hypothecation. Then I'll give you another example. It's an auto rickshaw. If you find every auto rickshaw, you have a board there, hypothecated to State Bank of India, Nacharam branch. What do you mean by that? Please remember, an auto rickshaw has to be assembled. When it is not assembled, when it is loose, it acquires the characteristics of a movable property. But once it is fastened with nuts and bolts, and you have the cover on top of it, and then you have the seats of the upholstery, and also the other parts like steering, so on and so forth. Because steering you cannot remove. If you remove the steering, you cannot run the auto rickshaw itself. So the question is, once it is fastened to that body, it acquires the characteristics of immobile property. That's the reason. Actually, auto rickshaw, before it being assembled, it is movable property. But once it is fastened with nuts and bolts and the body is built, it acquires the characteristics of immobile property. That's why the word that is used is hypothecated to State Bank of India. That means so long as the auto rickshaw is not assembled, it's a movable property. But once it is assembled and the body is built and the other upholstery is fitted to that, it acquires the characteristics of immobile property. That's the reason it's called hypothecation. And as far as the effect of hypothecation is, the financier or the banking institution has got the first charge over the auto rickshaw till such time the entire debt is paid, and you cannot transfer that vehicle without the NOC or the no objection certificate from the bank. And they also intimate the RTA that this particular vehicle is subject to hypothecation with the State Bank of India Nacharam branch, and no transfer should take place regarding this particular vehicle. Along with that, they take agreement of hypothecation, so on and so forth. Are you able to understand what hypothecation means? Hypothecation means pledge of immobile property. Like that, you can multiply a lot of examples. So section 58 is this. Now we come to the kinds of mortgages. There are 6 types of mortgages. Under section 58, there are 58A to 58F. 58A deals with what is called simple mortgage. Simple mortgage is there's a personal liability to pay on the part of the mortgagor to the mortgagee. A. B. In default thereof, a particular property is earmarked for the purpose of securing the loan which is had and received by the loanee or the mortgagor from the mortgage. It is twofold. One is personal liability to pay. That is personal defeat. The mortgagor says, I will pay the money. Number 2, in default, the mortgagor keeps a property separately, creates a charge over that property, keeps it apart for the benefit of the creditor, and in case a default occurs, as far as the personal payment is concerned, the mortgagee can proceed not only for the personal liability, proceed against the mortgagor personally, as well as they enforce his charge over the property that is offered as security, and he gets twofold remedies as far as a simple mortgage is concerned. Then what are the rights of the mortgagor, sir? The rights of the mortgagor is once the entire payment is made, no amount is due towards the loan availed by him, then he has got a right of redemption. Then he can file a suit, ask for redemption and say, sir, I've already paid the entire amount, sir. I paid it with interest and so on and so forth. Please direct the mortgagee to release all the documents or securities which are had and received from me at the time, and the mortgage duly cancelled duly cancelled so that I can get back my documents. Then in that case, the mortgagor exercises his right of what is called redemption. As far as the mortgage is concerned, he can proceed personally against the mortgagor and also against the property over which the charge is created. So mortgagee gets two rights. One is a personal decree as well as in default a decree in respect of the charged property. So this, and please remember, every mortgage created of the value of 100 and above regarding immobile property has to be in writing and has to be duly registered under the law. So this is as far as simple mortgage is concerned. That is 58A. So in 58A, what are the reliefs which the mortgagee gets? He gets a personal decree, can proceed personally against the mortgagor, and also he can enforce the charge on respect of the property which has been created by the mortgagor to secure the loan in case of default. What are the rights of the mortgagor? The rights of the mortgagor is he can exercise his right of redemption and say, sir, I've already paid the money, and nothing is due. Here are the receipts, here are the payments which I've made, and please direct the mortgagee to give back all the securities which he has taken, and the mortgage is duly cancelled. So these are the rights of the mortgagor. Then we go to the second type of mortgage called mortgage by conditional sale. That is 58B. Okay, sir. Mortgage by conditional sale means mortgage by conditional sale is laid down in section 58B, whereby the transaction revolves around where the mortgagor ostensibly transfers title in respect of the property owned and belonging to him to the mortgagee, and also with the super added condition that if the mortgagor pays back the entire money which is due and payable under the mortgage, the property will be reconveyed back or retransferred back to the mortgagor, and the sale shall become void. Mortgage by conditional sale means where an interest is created in respect of immobile property and the mortgagor sells or transfers his immobile property to the mortgagee, and then with the super added condition that if the mortgagor pays back the entire amount within a fixed duration of time, the property which is ostensibly sold or where a security has been created in respect of that property shall become void, and the property will be retransferred back to the mortgage. But the only condition here is when draft such a document, the condition of reconveyance, the condition of retransferring has to be specifically mentioned in the document itself. Are you able to understand, please? Mortgage by conditional sale means where the immobile property where a sale takes place as far as immobile property is concerned, where the mortgagor transfers by sale the immobile property owned and possessed by him to the mortgagee to secure the debt, and also gives an undertaking that he shall pay the debt within a specified duration of time, and on payment the property which is offered as security or the sale which has taken place will be retransferred back to the mortgagor, and the encumbrances or the securities taken will be returned back. This is what is called mortgage by conditional sale. Then we go to 58C.
58C deals with what is called English mortgage. English mortgage. Please remember when I was an examiner in the Usmania University, when a student was asked define an English mortgage, he just wrote it as saying that English mortgage is a mortgage which is prevalent in England. Please bear it in mind, though it has got the prefix as English, it doesn't mean that it's only prevalent in England. Here, English mortgage means where the property is transferred, where the property is transferred by the mortgagor to the mortgagee by way of a sale, and added to a super added condition that once the amount is paid within a fixed duration of time, the property which is sold by or the titular interest which is created by the mortgagor will be returned back. The property will be retransferred back to the mortgagor and the sale shall become void. Here, sir, what are the rights of an English mortgagee, sir? As far as an English mortgagee is concerned, he does not become the owner of the property, though it is a sale. It is only a security. It's only to secure the loan that a mortgage is created. What he has to do is he must bring a suit to enforce the mortgage by selling that property through the modicum of the courts. As far as the mortgagor is concerned, if he has paid back the debt within the specified duration of time and the securities are still had and received by the mortgagee, he is entitled to get back the property and get the sale set aside as null and void and get back the property retransferred. He can exercise the right of what is called redemption. Right of redemption. Am I making myself clear to you, please? 58C, again I repeat, sir. English mortgage is where a date is fixed for payment. The payment has to be made by the mortgagor to the mortgagee with a fixed duration of time, and the title in respect of that property is transferred by the mortgagor to the mortgagee, subject to a superadded condition that once the amount is paid within that fixed duration of time, the mortgagee shall retransfer the property back to the mortgagor free of all encumbrances. Here, the right of the mortgagee is to bring a suit for sale of the mortgage property. But as far as the mortgagor is concerned, his right is to file a suit for redemption and to get the sale set aside and say that he has paid the amount within that fixed duration of time, and he can ask for a direction to the mortgagee to return back all the securities duly redeemed. That is English mortgage. Here, again I repeat, date is fixed for payment. There is a transfer of proprietary rights. Third one is there is a superadded condition that the debt has to be paid within a particular time. And if the debt is paid within that particular time, the property has to be reconveyed back to the mortgagor, free from all encumbrances, and all the securities had and received has to be restored back to the mortgagor. That is what is called an English mortgage. Then we go to the fourth type of mortgage. It is called usufructory mortgage. USUFRUCTARY. 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 Usufructory mortgage. It is also called possessory mortgage. I don't put some water. Just excuse me. As far as usufructory mortgage is concerned, you must remember this is mostly resorted to by film financiers and people who finance big industries. Here, suppose the mortgagor owns a very vast property. Then what happens is the possession of that immobile property is delivered by the mortgagor to the mortgagee as a security for the due repayment of the loan with a superadded condition that the mortgagee has to satisfy his debt from out of the rents, share of crops, annuities, or profits arising out of the business. Again, I repeat, where possession of immobile property is delivered by the mortgagor to the mortgagee as a security with a superadded condition that the mortgagee has to satisfy his debt from out of the rents, share of crops, annuities, and profits arising out of the business, and such a mortgage is called usufructuary mortgage. And please remember, title is not transferred in this case. What is transferred is only possession. And what is the superadded condition, sir? The mortgagee can remain in possession, collect the rents, collect the profits, or collect the annuities, collect the share of crop. Till what time? Till such time his debt is completely satisfied. And please remember, the mortgagee cannot file a suit for foreclosure or he cannot file a suit for sale. Why? Because what is transferred to him is only a possessory interest and not a titular interest. He can remain like a Maharaja in the property, collect the rents, and like a Nawab Sahib, he can collect the rents and keep quiet and refuse to deliver possession till such time his debt is completely repaid. But as far as the mortgagor is concerned, mortgagor cannot file a suit for redemption for the simple reason is the title is not transferred. What he has to do is he must file a suit for recovery of possession, and the period for within which he must ask for that is 12 years. So, usufructuary mortgage, a mortgagor cannot file a suit for redemption. Mortgagee cannot file a suit for foreclosure or for sale. He can remain in possession till such time the entire debt is satisfied. But as far as the mortgagor is concerned, mortgagor cannot file a suit for redemption because he does not transfer title. What is transferred is possession is transferred. He can ask for redelivery of possession, but he cannot file a suit for redemption. That is as far as usufructuary mortgage is concerned. It's the best form of mortgage if you ask me. Why? Because like a Maharaja, you can sit on the property, go on collecting the rents. How much you collect, you must meet proper accounts and all these things. Refuse to deliver possession till such time your debt is completely paid. And this is mostly resorted to in the film business. Then the fifth type of mortgage, which is contemplated under the Transfer of Property Act, is what is called anomalous mortgage. I could tell you, of course, please pardon me for using that word. Anomalous mortgage means it's something like a transgender. I don't want to explain what a transgender means because there are leading candidates also. The question is, it's a conglomerate or it's a combination of two or more mortgages contained in a single document. It is called an anomalous mortgage. It is something like what is called vegetable pulao. Here you have carrot, you have potatoes, you have cabbage, you have everything in that, and you have the masala, desala, and all. Also, so it's an agglomerate. That is, everything is combined in rice. You call it as vegetable pulao. So anomalous mortgage is nothing but something akin to vegetable pulao. Here, there is a personal liability to pay. There is a charge created in respect of immovable property. Say the property has been ostensibly sold as it is in a conditional mortgage. Then there is also a condition imposed that the mortgage debt will be paid within a particular duration of time, and the title documents are also deposited with the creditor or with the mortgagee by way of equitable mortgage. Then in that case, it's a combination of two or more mortgages contained in a single instrument. It is called an anomalous mortgage. Please remember, no advocate drafts an anomalous mortgage. Why? Because it's very difficult to decipher the rights, intercede the parties. It depends on the contract between the parties. You want to find in a vegetable ploy, you want to find potatoes, it will be there. You want to find cabbage, it will be there. You want to find carrot, it will be there. You want to find beans there, you will have. You want to find peas, it will also be there, and it will also be fine. So sometimes anomalous mortgage is not drafted because it is very difficult to decipher the rights of the parties. It's something like what is called a transgender. You do not know whether it is this or that, and that's why no advocate drafts an anomalous mortgage, because if you draft an anomalous mortgage, you will become anomalous. Please don't draft an anomalous mortgage, please. Last one is 58F. 58F is mortgage by deposit of title deeds. Here, in this respect, I had a discussion with the DGM of Canara Bank. We had a discussion by saying, sir, we use the word equitable mortgage. Sir, please remember, there are no in England, you have got title by equity. Equitable estates are recognized in England. But as far as India is concerned, we don't have equitable estates. We have got only legal estates. We follow the Windsorian principle. That is, in England, suppose the elections are held, the new prime minister comes from the front door and the old prime minister goes from the back door.
That is the respect they have got for conventions and all. In the same way, as far as 58F is concerned, the word that is used is deposit of title deeds. Here, how does it take? It is an unconventional type of mortgage where the debtor goes to the banker or goes to a financial institution, deposits his original documents either expressly or impliedly with an intention to create a charge over that original document and obtains a loan. Such a transaction is called a mortgage by deposit of title deeds. It is called an unconventional type of mortgage because there is no documentation involved. It is only purely oral. By mere handing over possession of documents of immovable property, a charge is created over the property. And that charge is also called the collateral security. Here, the procedure that is adopted by banks is first they take a letter from the mortgagor that he is depositing the title documents pertaining to the property, which is detailed below. He gives the description of the property and the various documents which are deposited by him. Then they send to the legal counsel, whoever is the advocate for the bank. Then the bank advocate scrutinizes the document, sends it back to the bank. Then the bank begins its documentation. They take the signatures on various documents like guarantee agreement, agreement for cash credit, so on and so forth. Then also what they do is they take a promissory note also, and the immovable property particulars are entered in a register called the EM register or the equitable mortgage register, which is kept and maintained by the bank in the regular course of business. And then after that, they take a letter that the documents are deposited. And then they ask the party to go to another post office. They give an inland letter with the name of the bank and post that letter that he is agreed to deposit the documents. And then after that, a confirmation is taken from him saying that the documents are deposited by way of collateral security to deposit of title deeds. Then after that, the appraisal takes place, and after appraisal takes place, the loan is sanctioned. It is called an unconventional type of mortgages. The loan transaction is not reduced to writing. The amount of loan is not mentioned. The interest charge is not mentioned. The EMIs which are liable to be paid is not mentioned. And term for payment is also not mentioned. Please remember, if all these things are reduced to writing, it has to be duly registered. That is the famous case of Das Bank's case laid down in 1947. There they say the memorandum of deposit of title deeds is reduced to writing. It requires registration. And under the Registration Act, every transfer of immovable property or every transfer which involves a creation of an interest or the value of 100 and above has to be in writing on a properly stamped paper and has to be duly registered. Please remember, most of the documents which are now found in banks are all drafted by the Imperial Bank of India, which was the predecessor to the State Bank of India. State Bank of India came into force or came into existence only in 1955 by the State Bank of India general regulations. But prior to it, we had the Imperial Bank, and all the banks, including the private banks, are following the pro forma, which is drafted by the Imperial Bank. Today, even the imperialism exists as far as the banking sector is concerned, and the customer is asked to sign on dotted lines. He is not even given time to read the contents. Please remember, in this regard, I will try to tell you one thing, that there is a guarantee agreement called continuing guarantee. And in the second page, I think column number 3 or clause number 3, the the liability of the guarantor continues even thereafter, even if the loan gets time barred against the debtor till such time the entire amount is due. The guarantor is liable. The guarantor cannot limit his liability to a particular duration of time or to a particular amount. So the guarantor, once and for all, something like a permanent marriage. You cannot leave your wife or your wife doesn't leave you. The same way, please study the document before you sign, but you will not be given time because they say a beggar cannot be a chooser. Once you want a loan, you have to sign on dotted lines. But please remember, the bank also is very, very careful. They take 3 documents from you every quarter. That is called AOD, acknowledgement of debt, that you are indebted to the bank, and you have executed document. Then confirmation of balances, that is the balance due as per that quarter is concerned, computed along with interest. You also confirm it. Then they also take revival letter that the documents already taken hold good and fresh documentation is not done. And please remember, banker is the only person who does not write the date with ink. He puts the rubber stamp there because he says to make it to look it as clean and green. He puts the rubber stamp. Rubber stamp can always be manipulated. But the question is that is the procedure followed by bank. And one more thing you must remember is once these documents are taken, your goose is cooked. You cannot deny your liability. And please remember under Article 1 of the Litigation Act, they call it as current, open, and mutual account. Whenever you want a loan, you must open a current account, and it should be open. There should be mutual credits and mutual debits. And from the last date of debit or last date of credit till the account is closed, the limitation period starts. The limitation period gets extended. Revival letter is taken from you because the documents which are already taken from you holds good and no fresh documentation is done except when extra collateral security is furnished. The limits are enhanced. If not, fresh documents are not taken from you. This is as far as deposit of title deeds is concerned. And please remember, we are depositing the documents,
Original documents of title with the bank, with the financial institution, creates a charge over that property and doesn't require stamping, doesn't require registration. What all it requires is the original documents has to be deposited, and there must be a confirmation also that the original documents are deposited. Here, in this regard, I will like to discuss a case of the Supreme Court, the case of Bapuswamy, Bapuswamy, Bapuswamy versus Patti, Patty. I think it's decided by the Supreme Court in year 1972 or 1974 Supreme Court. Here, they evolved the doctrine of what is called letter of the law and spirit of the law. Here, what happened was the debtor had a property worth, had a property worth about 800. I'm talking about the olden days. It arose from Kerala. I think you know the name itself is from Kerala. And he was indebted to the creditor to the extent of some amount. Then he was indebted to the extent of 400. The loan which he took was 400 rupees, but the value of the property which was given as security was 800 rupees. But what happened was the title still remained with the Mr. Patti, and he was sowing the crops. He was enjoying the property. He was deriving the income out of the property. Possession was not delivered. Title was not delivered, but it was found that the loan was only 400, but the security that is offered is 800 rupees. Much the security is much more than what the loan is. The court said the transaction has to be viewed, even if it is couched in the form of a sale deed. The court can go deep into the matter, penetrate deep into the matter, find out what is the spirit of the transaction, intercede the parties, whether it's a purely out and out security or whether it's an out and out sale. In this case, the Supreme Court held saying that it is only a security and the debtor was entitled to redeem the property. So the question is, as far as the composite Andhra Pradesh was concerned or Tamil Nadu is concerned, here we have got the Moneylenders Act, and in Tamil Nadu you got the Pawnbrokers Act. No one can conduct a pawnbrokers business or money lending business without a proper money lending license. So to avoid that, most of the government servants lend money not in their names but in the proxy names. Then in that case, what happens is they a lot of hybrid documents are coming to existence, sir. The person had no intention to sell the property, but he is offering it only as a security. Then in that case, the court can go deep into the matter. What is the spirit of the transaction? Whether the person really intended to sell the property or when it's offered as a security. Letter of the law is not important. Please remember, letter of the law means 1 plus 1 only means only 2. But courts are empowered to make 1 plus 1 into 4 by going deep and penetrating deep into the matter, finding out the intention of the parties, what is the value of the property, what are the rights enjoyed by the parties, whether it's a loan or whether it's a security or whether it's an out and out sale. Because when you go into the spirit of the document, you can definitely find it out. So that was what was held by the Supreme Court. And today, even that finds favor with most of the courts. Please remember, nowadays we are coming across various hybrid documents, agreement of sale and purchase, memorandum of understanding, so on and so forth. But the question is, what all you say, the interpretation is important. interpretation of a document, the court can go deep into the matter, whether to avoid a particular law, this document has come into existence, what is the spirit of the transaction, what is the real intention of the parties, all these things can be gone into. So that is the present scenario as on today. So this is as far as section 58 is concerned. Then we go to section 59. Section 59 is mortgage by assurance. As mortgage above 100 has to be registered, signed by the mortgagor, and attested by two witnesses. So, which is to be by assured. That means every mortgage of the value of 100 and above has to be signed by both the parties, the mortgagor and the mortgagee, and every transaction of the value of 100 and above has to be duly registered, and it has to be attested at least by two witnesses. These are the requisites of a valid mortgage. First and foremost is mortgage has to be reduced to writing, it has to be properly stamped, and on the mortgage of the value of 100 and above has to be compulsory registered. It has to be signed by both the parties and attested by at least two witnesses. It constitutes a valid mortgage. That's what 59 reads. Then we go to, sir, there's not much of importance attached to it. Section 60 is very important. The maxim in section 60 is once a mortgage, always a mortgage. Here it said rights and liabilities, right to redeem liabilities of the mortgagor. Here, the fundamental principle is that the right to redeem
And the right to foreclose are coextensive with each other. They are like twin brothers. One brother cannot live without the other. The question is the right to redemption is available to the mortgagor, and the right to foreclose or sale is available to the mortgagee. Both have got independent rights. Both need not wait for each other. And under Article 61 and 62 of the Limitation Act, as far as the mortgagor is concerned, the period of limitation is previously it was 60 years, now it is 30 years. Within 30 years, at any time, we can redeem the property, provided his right of redemption is not extinguished by a decree passed in favor of the mortgagee. But as far as the mortgagee is concerned, he has got a right to enforce the mortgage when the amount becomes due by enforcing his right, and the period within which he must enforce his right is 12 years. As far as mortgagor is concerned, it is 60 years, 30 years. And as far as mortgage is concerned, it's 12 years. And both are coextensive with each other. Both, one need not wait for the other. At any time when the money becomes due, either the mortgagor can file a suit for redemption or the mortgagee can file a suit for recovery of the mortgage debt. And please bear it in mind. And some of you are going to become judicial officers also. Whenever a financial institution files a suit, it is normally, mostly the banks, they have got the collateral security with them. Please bear one thing in mind, Article 61 and 62, within 12 years at any time, the suit can be brought. Though the for the promissory note, this is the primary security, it is 3 years period. But if it is secured by mortgage, it is 12 years as far as the mortgage is concerned. As far as the mortgagor is concerned, he can file a suit within a period of 30 years as contemplated in Article 61 of the Limitation Act, provided his right has not been extinguished by a decree passed in favor of the mortgagee. This is a fundamental principle. You have to bear it in mind. And one need not wait for the other. They are like twin brothers. Both of them sail together. The mortgagee need not wait for the mortgagor need not wait for the mortgagee. So the question is, each one can file an independent action, but the period of limitation is entirely different. As far as the mortgagor is concerned, it is 30 years. As far as Article 61 is concerned, as far as the mortgagee is concerned, it is 12 years as far as 61 and 62 are concerned. Here, this particular section 60 says, once a mortgage, always a mortgage. That means a mortgage transaction cannot be converted into a sale transaction. A security that has been given cannot be construed as an outright sale. A security remains a security till the end. There is no question of change of color. So here it is said, such right uh, available unless extinguished by an act of parties. A notice has to be notice
has to be given. In redemption cannot be taken away. Please remember, this is a valuable right. As far as the mortgagor is concerned, the right of redemption cannot be taken away. It cannot be avoided. The question is, even the document should not say the mortgagor shall redeem within 3 years. If he does not redeem within 3 years, all the rights of getting back the property will be lost. This in law is called clog on the equity of redemption. Clog, C-L-O-G. Clog on the equity of redemption. Clog means repugnant conditions. Here, suppose the mortgage deed says he has to redeem within 3 years. If he does not redeem within 3 years, for 20 years he cannot redeem it. That clause, which takes away the rights of redemption within the period whenever the mortgagor wants, is a clog. It's a repugnant condition. It is void right from the beginning and cannot be enforced. So the right of redemption is a valuable right that is given to a mortgagor and cannot be taken away by a document. Then, in it are a mortgage by conditional sale, anomalous mortgage, as the sale is not confirmed, the mortgagor can deposit the entire sale money. In 1995, SCC 161, a case of New Kembleworth Hotels versus New Kembleworth, 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 Kembleworth Hotels versus Ashoka Industries Private Limited. It was held that it arises a mortgage by conditional sale, anomalous mortgage. So long as the sale is not confirmed, the mortgagor can deposit the entire sale consideration into the court. That is, instead of retransfer, the mortgagor can ask for arrangement for assignment of the debt. Here, it is said what the mortgagor can do is, without waiting for the mortgage to enforce the mortgage, be it a mortgage by conditional sale, be it an English mortgage, or be it an anomalous mortgage, deposit that money into the court. And once he deposits that money into the court, he is entitled to get back the property which has been offered as security and exercise his right of redemption. This was laid down by the Supreme Court in 1995, 1 SCC 161, in the case of New Kembleworth Hotels versus Ashoka Industries Private Limited. Then Section 60 goes further by saying, instead of retransfer, the mortgagor can ask the assignment of the debt to a third person as per his desire. So suppose a mortgagor has got the option under Section 60A by saying, sir, why do you want to take the trouble? You assign it to someone else and that person can proceed against me. We can direct the mortgagee to assign his rights, the rights in respect of the security, to a third person. That is what 60A says. Then 60B says inspection of production of documents. The mortgagor is entitled for inspection and he can also ask for the production of the document. He can inspect what are the documents executed by him, what are the documents which are in possession of the mortgagee. He has got a right. Then 61 deals with right to redeem separately or simultaneously. Suppose there is the same creditor and same debtor. Two mortgages are created. Mortgage A, mortgage B. Two properties are offered as security. Then in that case, the mortgagor has got the right of redeeming the mortgage separately or jointly or simultaneously. Suppose let us say the same property is offered as security and a loan is obtained, and the same property is offered as security and a second loan is taken. Mortgagor can redeem both the mortgages, pay back the debt, and get the properties, or he can redeem one mortgage, the first mortgage, second mortgage will remain. He can redeem it at a later date. That is what is called Section 61. I think with this we'll close, and now we go to the interaction period, please. We have completed up to Section 61. The interaction starts. Any questions, please?
If there in chat box, somebody asked some questions. Sir, is personal liability only in the case of simple mortgage?
As far as all mortgages are concerned, personal liability is available everywhere. Be it an anomalous mortgage, be it a mortgage by deposit of title deeds, be it an English mortgage or mortgage by conditional sale. It's available, but especially it is made in a simple mortgage because first you have to exhaust the personal liability and then proceed against the property which has been offered as a charge, not against charged property before going for personal liability.
Mr. or Mrs. I don't know, Redmi 9 madam or sir, మీ క్వశ్చన్ ఏదన్నా ఉంటే అనురాధ గారు ప్లీజ్ ask your questions directly so that everybody will get to know. Maybe sir, receive clarification. Anuradha garu, please unmute your mic and ask your questions. Anuradha garu. She's there or not? Yes. In bus ma'am, disturbance. Okay. Okay, madam. Anybody? Any more questions? Vasantrao garu, please unmute your mic, sir. Yes, please.
Vasantara,
In subsistence of agreement of sale, the vendor has sold the property to third parties. If I want to file a suit, I want to make them the subsequent to purchase also partition.
you have to
Then
definitely
what-
make because and take an injunction also the subsequent purchases should not alienate the property.
Okay, we have to seek cancellation of the document, or we have to make
Is
partition
it an
by
agreement of sale or is it sale deed in favor of a third person?
both subsequent vendor and vendor. Proposed vendor has to jointly execute in my favor.
So I'll put it this way, sir. A is the vendor and he has executed an agreement of sale in your favor, your client's favor. Then subsequently,
Yeah.
the same A executes an agreement of sale or sale deed in favor of C.
Yes.
In favor of C.
Yeah.
Then in that case,
Yeah.
you must get your agreement enforced by filing a suit for specific performance, ask the vendor to execute the sale deed, and also make the subsequent purchaser also a party saying that the earlier agreement was subsisting. He purchased the property with notice of the earlier transaction. So both of them should join together and execute the sale deed. So you have to make the subsequent purchaser also a party, sir, to be on the safe side.
What will be the issue, sir? Issues. What will be the issues?
Issues should be whether the plaintiff is entitled for specific performance. What is the effect of the second sale in favor of Mr. C, that is one of the defendants, and whether it's bona fide or whether it's in good faith.
Okay, sir. Okay, thanks.
Next, anybody? Okay, Anuradha garu bus lo ఉన్నారంట. Chat box లో అడిగాను. Sam, you can continue. Mr. Sam.
Yes, sir. Good evening, sir.
Good evening.
This is related to mortgage only, but
Issues
in
related
this,
to mortgage.
not also the individual person.
Sam garu,
As-
please little bit loud, sir. You're not audible.
1 minute, ma'am.
Yeah.
Am I audible, ma'am? No.
Yes,
Not
Mr.
not clearly.
Hello.
Yes,
Yes,
Mr.
yes.
Sam.
Now okay. Mr. Sam, you can go ahead.
Actually, one individual person have granted the loan actually to a certain person. Okay.
Yes,
So this person was unable to repay the loan amount.
right,
So because he has deposited that title,
right.
so this person has taken the, possession of the property,
Right.
and he's in the property for almost 10 years, more than 12 years.
Uh-huh.
So what is the remedy for the person to get back that property?
See,
The
yes,
client
sir.
has come and asked me this.
Has he executed a mortgage deed?
Nothing has executed, just on a bond paper he has written something. Nothing as such.
Then in that case, you must file a suit for delivery of possession and ask for damages and compensation also for that period for which he has been in possession, sir.
Okay.
But
he has to repay the loan, right, sir? He has not repaid the loan.
He has paid the money?
No, sir, he has not paid the money. It is just 1 lakh rupees.
Yeah, whatever is due, kindly deposit that money to the court.
Oh.
Yeah. And file a suit for possession.
Sir, one more follow-up question, sir.
Yeah.
Out of all this mortgage, different kind of mortgage, which is the best one? Which is is suitable for us as to take a mortgage or property
as far as we are concerned, sir, the best mortgage is simple mortgage and English mortgage, sir. Or even you can go in for mortgage by deposit of title deeds. No documentation is there in that.
Sir, one more question, sir.
Yeah.
Sir, what do you mean by Gramakantam land, sir?
Gramakantam land is something like Porambok, sir, which is lying on the countryside where no one has title. The government has got paramount rights over that land. That's called Gramakantam.
Okay, sir. Thank you.
Yes, thank you, Mr. Sham. Anybody? Any more questions? Okay, Anuradha garu chat box ko పంపించారు. Sir,
sir, could you please repeat that case law, sir? When you said that a patty where the value of the property.
Bapu Swami versus Patti. That is AR 1974 Supreme Court, where what happened was Mr. Patti was owner of certain agricultural land. He borrowed a sum of rupees 400 from the creditor, and here Bapu Swami is none else than the executor of the original creditor. Sir, creditor is gone, but his executor initiated action against Patti, claiming the amount. And it was housed in the form of a sale deed. But what happened was, Patti was able to show that the value of the land on the date of the transaction was 800 rupees, and the loan that was taken is 400 rupees, and a person cannot knock away property worth 800 rupees for 400 rupees, and said if you go into the spirit of the document, and the document is nothing but only a security and not an out and out sale. But the Supreme Court in this case said was, when such a transaction takes place, to circumvent any law for the time being in force, the spirit of the document can be gone into the real intention. Because here, possession was not delivered, title was not delivered, Patti remained in possession of the property. He cultivated the property. He raised the crops in respect to the property, and the original creditor did nothing in respect of that. In this case, the Supreme Court said the spirit of the transaction has to be gone into, and they held it as a security and allowed Patti to take back the property duly redeemed. That was the judgment of the Supreme Court, sir.
Okay, thank you.
ఒకసారి రిపీట్ చేయమంటున్నారు.
AR 1972 or 1974 Supreme Court, sir. I don't remember the page. There's a famous case of Bapu Swami versus Patti that arose from Kerala High Court.
Koteshwara, are you clear with your doubt?
Clear, madam. Thank you.
Right, sir. Thank you. So there is a practice in some places where a bigger sum amount is paid at the beginning and the person stays as a tenant. And when he leaves, the entire amount is paid back by the landlord. Is that a lease or mortgage?
This, what you are referring to, is in Karnataka. In Karnataka, what happens is, suppose a tenant is inducted, you pay 3 years rent or 5 years rent at a time, and that is rotated in the business. And what happens is, you did not pay the rents every month. And once the 5 years period comes to an end, that amount, what you have advanced, becomes adjusted in the rent, and whatever shortfall is there, it is given back to you. But the question is, suppose you want for another 5 years, this is one of the ways of raising capital for your business. This is prevalent in Karnataka only, not in Hyderabad.
Sir, if a lease deed is for more than 12 months, if not registered, can it be used to claim the security deposit paid or to show that the tenant was in possession?
Are you a tenant or are you a landlord?
She's unable to talk at the moment.
See, as far as security deposit is concerned, even in the principles of the law of contract, also you can get it back. Again, the specific relief also says, again, the principle of unjust enrichment, the document has to be read. Security deposit has to be returned or adjusted. You'll have to see that clause. If that you see the clause, it will be very, very clear. If it has to be returned, it has to be returned. There's no question of going back on that. And there is no need of but if the rental agreement is not registered, let us say, then in that case, even for a collateral purpose, under section 49 of the Registration Act, the question is it has to be returned back. For a collateral purpose, the nature of the transaction can be looked into.
Tenant అని చెప్తున్నాడు మేడం.
So if the tenant is there, he is entitled for the return of the security amount.
Yes, the practice is Karnataka. So
Only-
is
only
it
in Karnataka.
mortgage or lease?
Okay.
Is it mortgage or lease?
It is not a mortgage, it's a sort of a use-effective mortgage.
Yes, Anuradha garu, are you clear with your doubts? Yes, any more questions? Anybody have any doubts? Or book? What? Book అడుగుతున్నారు సార్ లిమిటేషన్ నాకు సంబంధించి. She wants a book.
Book on limitation.
Which one second.
Book
Would you,
on-
which is a good commentary on law of limitation. Commentary, not
Law
book.
of limitation, Chitale's law of limitation is there. Sanjay Rao's law of limitation is there. Justice P.S. Narayana's limitation act is there. Even the Panchayat publications of Padala Ram Reddy also is there. But for limitation act, you need not go into the commentaries, please. Their act is sufficient.
Okay. Any more questions, sir? Any more questions, madams? Okay, no? Yes. Mr. Ram Narayan garu. It's not responding. Okay. Mr. Ram Narayan garu, are you there? Not responding. Any more questions, sir? Or shall we conclude? What is this 999 years lease or 99 years lease?
See, as far as 99 years lease or perpetual tenancy is concerned, it's not prevalent now. There's nothing like perpetual lease. Perpetual lease is not existing as of today. I think perhaps what you are referring to is to Alpha Hotel. Alpha Hotel had near station, Second World Station, they had a lease for 99 years. Afterwards, it was extended for 30 more years. Very rare cases you come to perpetual leases. Perpetual leases are not existing today.
A vendor arrived at sale agreement with Wendy. Vendor expired before executing sale deed, leaving widow and children of previous marriage. Wendy filed suit for return of money. The children filed suit for partition. How can the interest of Wendy of sale agreement?
As far as the vendor is concerned, he can get that agreement enforced as against the estate and make the in-laws liable. But as far as personally concerned, the in-laws are not liable. You can ask for specific performance and file it against the in-laws of the deceased.
Vivo Y27. Are you clear with your doubt?
Jamuna.
Jamuna is not here.
Okay.
Vivo Y27. I don't know who is she.
No doubt, sir. No doubt.
Okay. Sir, why is lease usually made for 11 months when registration is for more than 12 months?
11 months it
Let
was
me know.
made, taking the old view into consideration. That is, the old view was it didn't require registration. 11 months only proper stamp has to be there. But now the present view is even if it's a 1 month, it has to be in writing and it has to be properly stamped and it has to be registered under 17(1)(b) of the Registration Act. Is it clear to you, madam?
Yes. Any more questions? chat box లో అయితే as of now. Hmm. చెప్పండి సార్ మీరు చెప్పండి. Yes. Yeah, you're here on the yes.
So this particular lecture is meant for people like you and me who are mediocres. My lecture is not for extraordinary people who have got high IQ. And please remember, I'm going from fundamentals itself, citing rules, citing the sections, and also wherever possible, trying to illustrate it. If you find that there are some shortcomings, please try to point it out so that I can correct myself. And when you are asking a doubt, when I'm responding, please try to answer whether you are following it or not, so that I'll be satisfied that I'm able to explain to you. Thank you very much.
Right. That's all for today. Good night. Thank you, one and all.
Good night, sir. Thank you.
Thank you.
Right, sir. Thank you.
Thank you, sir.
Thank you. Thank you.
The pastor got to know you.